Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumbs.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan.
Megan Fox.
Megan.
Megan.
Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh**.
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's.
You pissed off the wrong woman.
Oh my God! I have been assaulted, but Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan.
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 Megan Fox.
Mr.
Thank
Atkins,
you.
cheers.
Cheers.
Hey everybody, how are you? It's me. Good morning, locals. Good morning, Rumble. Those of you, I just made a bunch of you Rumble mods. Please keep up with the bots over there because I don't know what the heck is going on over on Rumble, but the bots are out of control. So I wrecked my little earbuds, unfortunately, so I'm back to the big ones over my ears. It's kind of crushing my hair, but oh well. I guess we'll just have to deal with it till I get new earbuds, but they're making crackling sounds, so I guess I got to get new ones. All right, here's the deal. It's a really nice day here in New York. It's sundress weather, and I really want to get outside and enjoy my garden, so I almost didn't come on to do this today. I was like not feeling it. I really just want to be outside playing with the dog and the chickens and stuff. So you guys are going to have to help me through it. I want to get through it as quickly as possible, because I want to go play outside in the sun. So we are going to read Gregg Woodnick's new motion, and I'm going to read through it as quickly as I can, and then we are going to get to some relevant information, some relevant stuff on text messages between Greg Gillespie and Laura Owens that really relate to this filing. And Gillespie, Greg Gillespie has not had enough attention really in this. We started going over the Gillespie files here, and I didn't get through them all, and now there's a lot more. Like, it's hard to keep up with this case. It really is. There's just so much going on at the same time. But good to see you in the locals chat, by the way, meganfox.locals.com. If you want to be a part of the locals chat, it's always a good time over there. Always, always, always a good time. That's where the memes flow. And I know that some of you are like, son, in Rochester? Since when? Since today. So, you know, it's important to take advantage of these things when they occur, because it doesn't happen very often, folks. It does not happen very often. All right, I don't have the YouTube studio open, so I need to do that. Nope, that's not it, Megan. That's the wrong address. Yep. Got typos here for some reason. All right. Let me try and open this, and then we're going to get straight into the new motion from Gregg Woodnick, which should be pretty interesting. I read through it this morning. It's really good. It's only 13 pages, and then we have some exhibits, and the exhibit emails are really something. I mean, and that's what brings me to the Greg Gillespie text messages, because we've got David, is his name Gingras or Gingras? I don't know, but we've got Dingus, who is claiming some crazy stuff in these emails that we know is not true. He's claiming that Laura Owens never told Greg Gillespie that she was, well, I think he said she never said she was pregnant with twins, and then she never tried to keep the pregnancy. All this nonsense that is not true. It's just not true. So we'll get into it. We're going to get into it right now. Here we go. All right. This is the response objection to petitioner's motion for judgment on the pleadings and renewed motion to dismiss. Defendant respondent Clayton Eckert by and through counsel undersigned. I think I'm going to put myself over here. Hereby files his response and objects to plaintiff petitioner Laura Owens' motion for judgment on the pleadings and renewed motion to dismiss filed May 10th, 2024. General availability of attorney's fees and sanctions. Before addressing the balance of the motion on its face, the court must be aware that Laura's entire argument presents a false choice fallacy in an attempt to artificially limit both the scope of the pleadings and the court's authority. Rule 26 is not, and has never been, the exclusive source of the court's authority to award attorney's fees, and it does not govern Clayton's substantive claims for relief raised in the pleadings. Therefore, the question before the court is not whether it can award sanctions under Rule 26 or no sanctions at all, as Laura falsely frames her argument. Oh, I just realized I didn't put this out on Twitter. Why? Why didn't I do that? Hold, please. All right, there we go. Back to the filing. As Laura falsely frames her argument, rather, the question is whether Clayton is entitled to adjudication on his claims for fees and sanctions under any authority invoked in the pleadings or inherent to the court by virtue of its statutorily mandated duties. So in other words, you don't just have to, sanctions aren't awarded just based on filing a Rule 26. The court has its own authority to assign sanctions. The answer to the question is clearly yes. Laura knows, or at least she should know, based on the plethora of written communications and filings about this issue, that her proffered Rule 26, or dismiss the action dichotomy, is both frivolous and misleading. Frivolous and misleading. That could be a name of a new hit song, or possibly the documentary about this case. Frivolous and misleading. Title 25 contains at least 3 statutes that expressly instruct the court to award attorney fees and sanction a party in response to unreasonable conduct in the litigation. ARS 25-324, attorney's fees and actions under 25-401 through 25-417 for unreasonable conduct. Ooh, I like that one. I like the term unreasonable conduct. I feel like we could assign a lot of that to not only Laura Owens, but her attorney. His conduct has been incredibly unreasonable, threatening people with Conor McGregor nonsense. Niche Scholar says, is it just me or did the stream stop working for everyone else? Well, I hope that's not, I hope it's just you. Try refreshing, Neat. Oh, he can't hear me. Can he? I hope it's still working. Is Rumble still up? Somebody confirm. All right. Title 25. Okay, I already did that. Sanctions for presenting false claims. Well, that's been done here. Or violating orders compelling discovery. She did that too. She violated discovery orders. Didn't show up to a deposition. Didn't turn over her discovery. She's done all of this stuff. God, I'm getting worked up already. Attorney's fees for unreasonable positions in paternity proceedings. Well, there's been a lot of unreasonable positioning. I would say, don't say position in relation to this, in relation to this stream.
Phrasing?
There were a lot of unusual positions going on. Clayton has already articulated in several filings, including his motion for leave to amend, amended response, response objection to petitioner's motion to dismiss, and motion to withdraw the motion for sanctions pursuant to Rule 26, the statutory basis for his claims for relief. Moreover, those provisions apply to all proceedings brought under the relevant chapters of Title 25, of which this paternity action is one example. Every litigant has notice of the court's duty and authority to sanction unreasonable conduct in family court actions. Rule 26 is a procedural mechanism for sanctioning a party for the contents of their filings at any time, even before final resolution and notwithstanding the prevailing party in the action, and does not replace, supersede, or otherwise affect the statutory claims for relief whatsoever. Footnote number 1. To crystallize this point even further, Rule 26 is not even the exclusive source of sanctions in the procedural rules themselves. The court can sanction a party for service violations in Rule 43.1, discovery violations, Rules 51 and 65, and failure to participate in various aspects of the proceeding. Oh, you mean like deposition? Like failing to show for a deposition? Yeah, to name a few. Go back up here. Arizona courts have repeatedly recognized that when a substantive statute conflicts with a procedural rule, the statute prevails. Albano v. Shea Hose. She belongs to the streets. Limited partnership. See also in Remarriage of Waldron. Court rules may not abridge, enlarge, or modify substantive rights of a litigant. Rule 26 governs relief pursuant to Rule 26 and nothing more. Even if Laura's arguments interpreting Rule 26 were correct, a conclusion Clayton certainly opposes, the net result on the posture of the case would be absolutely no change at all from the existing trial scheduled on the merits of the pleadings. Accordingly, her prayer for relief, improperly styled as a motion for judgment on the pleadings and renewed motion to dismiss, was already moot before it was even filed, because Rule 26 is not at issue. The motion has no bearing on the resolution of this case. Yeah, he withdrew his motion for Rule 26 anyway, so it's moot. As detailed in prior filings, by withdrawing his Rule 26 motion, Clayton hoped to avoid Laura's noxious agenda of papering the court with dozens of pages of meaningless debate on this topic. But Laura appears determined to have this purely theoretical argument regardless. You know, I meant to do this before I started this stream. I was actually going to go into Dingus's filings and print them out, just the ones that I have saved to my hard drive, and I was going to start papering the wall behind me, because I bet I can already cover it like wallpaper in the I think I should do that at some point. Let's see, how many do we have? Oh my god, look how many we have. Look how many we have. Let's just open one of them. How many pages is this? Alright, let's see. I'll start printing. Let's start printing this. Let's see. Why did it do that? That's weird. Yeah, I want that one printed. Alright, we'll start papering the wall behind me for this crap. Don't waste the paper. Well, it'll be funny. It'll be a funny, let's see, am I on the right one? Start document. Which one is this? Yes, I'm on the right one. All right, let's get back over here. Oh, there goes the printer. I think I started with one of his least annoying ones that was only like 5 or 6 pages. All right, we'll see. All right, a conclusion. We already got that. As detailed in response to motion for judgment on the pleadings, as and for his response objection, Clayton states as follows. Clayton provided written notice as required by Rule 26, Arizona Rules of Family Law Procedure, through emails and filings. Footnote number 2. This is all addressed ad nauseum in Clayton's motion to withdraw, which is provided as an exhibit for the court's convenience as a litany of unnecessary filings designed with the overt goal of delaying or otherwise avoiding trial, as here, with the motion for judgment on the pleadings have followed. I mean, obviously, this guy is doing this on purpose to make this drag out as long as possible. Jacqueline says you're wasting a tree, Megan. What do we have here? We only so far we only have exhibits, and oh look at how much I have so far. Where's my tape? Oh, the kids took my damn tape again. They're always stealing the Scotch tape. It's like the Scotch tape is one of the most coveted items in this whole house. I swear to you, whenever I have Scotch tape, it gets appropriated by the children so that they can hang stuff all over their walls. Oh, I found some. Haha, a hidden Scotch tape. All right, let's see how far we get. We're papering the walls with Dingus's motions. This is what the court is putting up with. Imagine you come into work and you're forced, Judge Mata, forced to read so many pages. Like you could literally wallpaper your office in them. Boy. There we go.
Do you want me to read the motion while you're papering your wall?
Yeah, sure.
Which line were we on?
2 or 1 right here.
Okay. Clayton provided written notice as required by Rule 26, Arizona Rules of Family Law and Procedure, through emails and filings. Footnote 2. Footnote 2 is good, but not as good as 3.
We read 2, didn't we? I did. I just read it.
Okay.
So we were right there. As addressed.
As addressed in depth in his motion to withdraw, Clayton's motion for a leave to amend, filed December 12, 2023, Exhibit 1, provided notice of his intent to seek sanctions against Laura and cited Rule 26. The court granted leave to amend and accepted the amended response, also citing Rule 26 and indicating an intent to seek sanctions against Laura on January 25th, 2024. On December 28th, 2023, more than 10 days after being notified of Clayton's intent to seek Rule 26 sanctions via the motion to leave to amend, Laura moved to dismiss her petition because she was, cryptically, no longer pregnant. Clayton timely objected. On January 25th, 2024, the court deliberately indicated it was not dismissing the action because Clayton is entitled to resolution of his claims for a finding of non-paternity, attorney's fees, and sanctions. See minute entry dated 1/25/2024. See minute entry dated 2/14/2024. It is ordered denying petitioner's motion to dismiss. See also Rule 46A1B, prohibiting voluntary dismissal without court approval after an answer is filed, permitting the court to dismiss a petition on such terms and conditions the court deems proper, including the resolution of any claims by responding party. Holgate v. Baldwin, 325, blah, 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 blah. The court upheld an award of sanctions despite parties not sending a separate notice of their intent to seek Rule 11 sanctions, finding that the safe harbor period commenced when the parties filed their initial joinder motion evidencing an intent to seek sanctions, emphasis added.
Emphasis added.
Even if this court finds Clayton did not provide proper notice, Rule 26 is just one avenue for sanctions. If the court treats Clayton's response for petition for paternity as true and correct, as Laura now requests, there are independent statutory claims for attorney's fees and sanctions that have nothing to do with Rule 26 sanctions and have no safe harbor provisions. Statutes are superior when it comes to substantive claims, and rules are superior when it comes to procedural matters. And the statutes provided substantive claims for relief separate and apart from Rule 26. Rule 26 is a carryover from the Rules of Civil Procedure as a remedial measure for frivolous claims and filings during the pendency of the proceedings, not a mechanism for defeating substantive statutory claims for relief, as Laura suggests.
By the way, I saw the comment last night that, what was it about your voice? Somebody on MG's, somebody sent in a chat that said your voice was...
Smoke or...
Smoke show.
Smoke
Your voice
show.
is a smoke show. You didn't know what that meant. You don't know what that means?
I still don't know what it means.
It means hot.
Oh, okay.
It's a smoke show.
Well, generally, you would think that's more like a smoldering burn, not a raging inferno, so...
Read it to us, Brad.
As a broader legal point, case law interpreting the limitations of the court's authority to sanction improper filings in a civil matter is not directly analogous to Rule 26, insofar as Rule 26 exists in a completely different environment of statutory claims under Title 25, allowing different relief such as sanctions and attorney's fees by statute. Interpreting Rule 26 as an analog to Rule 11, Arizona Rules of Civil Procedure makes sense in the context of language of the rule itself. But once the analysis moves beyond that and onto the question of whether there are alternative grounds for the same relief, Title 25 is tremendously broad and more remedial than the legal authorities relevant to the various cases interpreting Rule 11.
All right, I have literally run out of space already. I'm not even through. I'm not even through one filing of his yet. What do you think? How's it looking? How's it looking? This is me papering my walls with David Dingus's. But I see a couple of spots. Hold on, wait a minute. There's a couple of spots that I can
got one right there and a couple right there.
One. Like we've got a little bit of a issue here. Let's see. I could probably get one right about here. There we go. But I mean, this isn't even one motion. Look, I still have. Look, this is one motion. We're still here. I mean, this is what the court's going through right now is just insane. All right, let's get back to let's get serious here. This is a serious show. Regarding the safe Haber notice provision. Harbor? What did I say?
Haber.
Haber? Harbor? Whatever. You know what? That portion of Rule 26 permits a party to correct or withdraw a filing within the notice period, but it is not an absolute right to withdraw the entire action. As previously addressed in his motion to withdraw, if Laura's theory that she was denied an absolute right to withdraw her entire action were true, no party would ever move for Rule 26 sanctions. Under Laura's view, that would hand the other side a Monopoly-style get-out-of-jail-free card to avoid consequences regardless of the extent of the frivolous, inflammatory, and impermissible claims in their filings, or the outrageousness of their conduct after filing footnote number 3.
Footnote 3 is good.
I know. Here, Laura's conduct in this action and the other two protective order proceedings clearly fall within all of these categories, as Laura allegedly, frivolously brought the underlying action alleging she was pregnant after non-intercourse with Clayton's twins and continued to perpetuate alleged fraud upon the court by submitting knowingly fabricated medical records. Laura has behaved inflammatorily by continuing to present herself as 24 weeks pregnant with boy and girl twins and repeatedly testifying to actively being seen by physicians who have since disclaimed ever seeing Laura as a patient, and by engaging in toxic diatribe on Twitter and blog posts, including attempting to intimidate witnesses. Damn, son.
Mm-hmm.
Nearly all of Laura's filings have contained legally impermissible claims. For limited example, Laura's motion to communicate and this motion for judgment on the pleadings. Lastly, her conduct in this litigation has been extremely outrageous, to wit, admittedly fabricating medical records, baselessly accusing others of fabricating the records she herself tampered with, and allegedly committing perjury in multiple filings and in statements before this court. Notably, Laura bizarrely appears to continue to allege that the sonogram that she admitted to doctoring and that did not originate in either location she alleged is legitimate, despite mountains of evidence to the contrary.
Mountains of evidence.
Mountains of evidence. Which is an independent basis for statutory relief, entirely independent of Rule 26, and then a bunch of laws. Laura's motion for judgment... Uh-oh.
We're losing motions.
We're losing... Hold, please. We've lost some of the wallpaper. I didn't do a great tape job. Here we go.
And yes, if anyone is wondering, we do have the minute entry that was posted this morning.
Yeah, so what was posted was just the judge ruling on the withdrawal of the Rule 26 motion, and she just, granted it. So nothing has happened. It's just that the Rule 26 motion that Gregg withdrew is now officially withdrawn. That's it.
And she had withdrawn it on the 4th when Dingus filed his non-objection, but for some reason it was clerically missed. So they were saying, oh, by the way, we actually did this. We just forgot to write it down.
Right. Flux says, new hit song, Mountain of Evidence. Yeah, possibly. But what? Things are just falling all over the place. Apparently the Scotch tape isn't going to hold. All right. Hey, let's hit some of the super chats. Hey, Joe, thanks for the 20. Says, to help with the needed new earbuds, thanks for all you do. I actually really like these because they're comfy, but the earbuds allow my hair to not be squished, and so that's always important. Carrie Beth Underwood, thanks for the super chat, says, excited to see this one. Oh, I'm glad you are. Michelle Webster, thanks for the super chat. For the Canadian money, says, found you through the hails. I just love your commentary. Well, I love that you're here in the audience. Thank you for being here. Fallen Hero 4567 gifted 1 Megan Fox membership. Welcome to the Fox Den. Whoever got that one. It's weird in here, but you'll get used to it. Cages, thanks for the 5, says, I would have just done a couple copies of the petition to compel lunch. It's all you needed for the wall. This wasn't even half of one motion. Michelle Webster, thanks for the Canadian too. Oh, the voice fans myself. See, they like it. It's the smoke show. They like it. The ladies like it. They like it. Sent you the, what does your private chat mean?
No. Never mind.
Oh, okay. I don't know what that stands for.
Minute entry.
Oh, right. Okay. All right, let's get back to this. Laura's motion for judgment on the pleading seeks the legally extraordinary and practically inexplicable relief of dismissing the entire action that she improperly brought. I love this. Yeah. I mean, exactly. She brings this thing to court. She wants a judgment on it. And then all of a sudden it's, oh no, I don't want anything done anymore. No, I want out. Yeah, no. Even assuming in arguendo that Laura was entitled to a 10-day miracle cure period to undo her past bad acts, she has already been given those opportunities and did not accept them. Yes, she moved to dismiss her petition eventually, but it was well after 10 days from Clayton's motion for leave to amend and was denied because Clayton has material statutory claims entitled to the resolution on the merits. There is simply no reason to believe there was ever a time that Laura would have voluntarily withdrawn her claims, even if she was given that opportunity with no strings attached. Instead, her antics continued, including alleging that a prior victim fabricated her medical records, which she now appears to be claiming she does not remember creating the allegedly fabricated medical records. Moreover, Clayton even offered several times for Laura to walk away from this litigation if she apologized and admitted that she was never pregnant by him with twins. Laura rejected every effort to resolve this matter and even engaged in overt efforts to intimidate witnesses into not participating in the process by threatening to have them arrested.
You are not a nice person.
As referenced in Exhibit 2, she, through counsel, mentioned having Mr. Maricini arrested for attending the hearing. His subpoena is attached. Then, she conveniently failed to mention in her recent reply in support of Laura's motion in limine that she has been in contact with Mr. Maricini and his attorney, and he has clearly indicated his desire to have his voice heard at trial. Exhibit 3. Moreover, on April 22nd, 2024, Laura, via counsel, stated, "I am happy to discuss settlement, but I also need to be honest. When Laura prevails in this case, she is going to sue Clayton and many other people for defamation and other torts. We can certainly avoid that if you want, but it's going to involve someone writing a very large check to Laura. If you offered $1 million right now, I'd advise her to reject that offer." Emphasis added. Wow, this guy.
Mm-hmm.
Wow. Ain't nobody going to be paying Laura Owens $1 million, dingus. I hate to break this to you, but this is something you just fail to grasp. And he knows this. He knows this. This is all bluster. She has no grounds. She has no leg to stand on. She has amputated both of her legs.
She was short already. She can't get much shorter.
She hired Fiverr to amputate both of her legs. In this case, she has literally no leg to stand on. Not a peg leg, not a crutch, nothing. Her own damn attorney said she is not a credible witness in a filing, that she lies about stuff. This is absurd. Hey, Sarah, I see you in the chat. Happy birthday, by the way.
Ooh, happy birthday.
Shit. Papers are just falling off the wall. They're just, my wall is rejecting Dingus. It's like motion denied.
Denied. Sit down.
My wall has decided to deny David Dingus's motions, and it's just, they're throwing it. The wall is throwing them off. They're just, we don't want this on our wall.
Denied. Sit down.
The wall is rejecting him. It is tremendously convenient for Laura to announce here at the proverbial 11th hour that she would have withdrawn the petitions months ago if given the chance. The well-documented history of this case and the companion order of protection cases where her conduct under oath was even more outrageous necessitates a different conclusion. Again, even if Laura had attempted to withdraw from the action entirely, that was only subject to the court's approval and Clayton's right to object consistent with Rule 46. Rule 46 must be read harmoniously with Rule 26. And there goes another one.
Denied. Sit down.
Judge Wall is making rulings faster than I can even believe. It's just...
Faster than Mata can read Dingus's motions.
One after the next. Denied.
Denied. Sit down.
The wall is like...
You will pay for what you've done. And I pray that God send angels to visit vengeance upon you.
Yeah. Again, even if Laura had attempted to withdraw from the action entirely, that was only subject to the court's approval and Clayton's right to object, consistent with Rule 46. Rule 46 must be read harmoniously with Rule 26 and Title 25 statutes. A harmonious reading of Rules 46 and 26 tells us that a pleading can be withdrawn voluntarily before a responsive pleading is filed. But after a responsive pleading is filed, it can only be withdrawn with the court's permission after consideration of the opposing party's right to have their responsive claims and counterclaims adjudicated. Laura has already tried this and was denied by this court.
Denied. Sit down.
The Rule 26 notice would allow a party to correct a pleading or withdraw a claim, but not to dismiss the action without the court's permission after an answer is filed.
Don't get brazen with me.
The court should not grant permission if, as here, the respondent asserted substantive claims entitled to adjudication in their responsive pleading. I like that sentence. The court should not grant permission if, as here, the respondent asserted substantive claims entitled to adjudication in their responsive pleading. So in other words, Clayton had substantive reasons to respond, and those responses deserve adjudication by the judge. And so by law, she can't just walk away. Nuh-uh, honey. Get back here. Notwithstanding all of this, a motion for judgment on the pleadings makes absolutely no sense in this case's context. Judgment on the pleadings would require the court to find Clayton's allegations in the response that Laura was never pregnant with his twins as true, and therefore find her subsequent representations to 3 different judges under oath were maliciously fraudulent. That kind of conduct is exactly why ARS 25.324, 25.415, and 25.809 exist. Her position here would turn Rule 26 into an escape hatch for any litigant wishing to avoid the consequences of their own actions. Yes, Ms. Owens, I'd like to introduce you to the consequences of your actions. Here it comes.
So the one thing to note here is that she filed this in August 1st, and Clayton didn't file the motion to leave to amend until December 12th. That's
so she had
5
all
months
that time. She had all that time to back out.
And that's including the orders of protection hearings and all kinds of other stuff that she put him through. And then by the time Woodnick files that motion, 5 months had passed, and a number of responses have had to go out paying for responses to hearings and all that.
Yep. No, she had plenty of time. Plenty of time. Her escape hatch. If Laura now concedes that her claims were always fraudulent, as Clayton believes, and the entire internet believes also, or just according to her counsel, misstatements, just a little minor perjury, then the court can proceed just in determining the appropriate sanctions and attorney fees to award. It still must award them pursuant to statute. 7. Whether Clayton filed for sanctions under Rule 26 or not, trial would still occur. Even assuming this court agrees with Laura's highly contested interpretation of Rule 26, the parties would still be heading to trial. Clayton is entitled to a hearing on his counterclaim for a finding of non-paternity and attorney's fees and costs. As Laura has repeatedly indicated in her filings, emails, blog posts, and tweets, she has no interest in conceding what Clayton has alleged since the beginning, that she was never pregnant by Clayton with twins after their non-intercourse. Had Clayton never mentioned Rule 26, Laura would have no safe harbor to withdraw her claims, and the court would proceed to trial under any of the half dozen or more other sources of authority to adjudicate the claims before it and sanction misconduct. Interpreting Rule 26 and the safe harbor period as a necessary precedent condition for the court to sanction a party under any other source of authority at law or in equity would be the most absurd result imaginable. The court cannot read a rule as requiring an absurd result unless that is the only plausible reading, and that is clearly not the situation presented here. Oral argument is an unnecessary and expensive distraction on the eve of trial. Efforts to delay and avoid this trial are over the top.
I have anxiety over the roof.
This is a bench trial that is set to take place in less than a month. If Laura desires to use this motion or her limited time at trial to argue about procedural rules that have no bearing on the substantive issues of this case, that is her prerogative and should count against her limited time. Clayton should not be forced to participate in such futility because his analysis of the Rule 26 issue has been thoroughly explained on the record twice. This is the Conor McGregor litigation that was promised by Laura's counsel and is only exemplified by the personal tweets, blogs, and what this court may see as efforts to intimidate for no reason other than to dissuade just resolution of claims. It needs to stop.
Shame, shame,
I want this woman in court when we get there. I want the woman with the bell just following Laura Owens and Dingus around like this. This is what I want. I want the shame bell. Just, you know what, one of you who's coming to protest outside, if you're doing any of that, someone needs to bring a cowbell and just walk around screaming, shame, shame, shame. I may have to bring my cowbell just for this, just to walk around shouting, shame, shame.
Bring
all
a
the
Scarlet
shame.
S while you're at it.
All the shame. Clayton is entitled to his reasonable attorney's fees and costs under ARS 25-324, 25-415, and 25-809 incurred in this entire proceeding, including in filing this response. Alex, perfect. I'll bring the bell. You walk around shouting shame. Clayton exhaustively outlined in his motion to withdraw most, if not all, of the factual and legal basis outlined in this response. Laura did not even reply to Clayton's motion. Instead, she agreed with it and filed a notice of non-objection. Flux says, I have a fever, and the only cure is more shame bell. You got it. You got it. Shame. Oh, so funny. The withdrawal was filed to avoid more of the toxic litigation, threats of appeals, and personal sanctions and bullying efforts. It did not work. Still, Laura seeks yet another impossible form of relief in a motion designed to increase expenses and avoid trial. She requests oral argument on the matter, despite already knowing constructively, if not actually, that her argument is not well grounded in law. Clayton requests that he be permitted to submit a China doll affidavit that includes all of the prior unwarranted and legally inappropriate filings he has had to defend himself against in this litigation. Oh my God, they're gonna paper the wall with them, because it's a lot. It's a lot. It's gonna be more than this. Wherefore, Clayton respectfully requests the court deny the motion for judgment on the pleadings and renewed motion to dismiss, grant Clayton leave to submit a China doll affidavit, and grant other relief this court deems just and proper. Okay, we're finally going to get to the exhibits in this. The emails are pretty interesting. So this exhibit is just his motion to withdraw. We can skip this because we've already read that.
Read that one.
Mm-hmm. Skipping down to the next one. Exhibit 2. All right, now we get to the emails. From David Gingras to Randy Sue Pollock, Owens trial. Ms. Pollock, I'm writing to document our discussion just now and explain my position. Per the email below, we spoke about your client, Mike Maricini, about 2 weeks ago. At that time, I told you I just wanted to speak with Mike and hear his side of the story. Yeah. Do you want to have a phone call?
No.
And I also explained that if Mike was going to be a witness in the Arizona paternity matter, I could and would be willing to subpoena him for a deposition if he was unwilling to have a simple phone conversation. Why won't you call me? Just pick up the phone. In response to that discussion, you sent me the email below stating that Mr. Maricini was not going to testify at the trial in June. Since then, counsel for Mr. Eckert has indicated Mr. Maricini will be testifying in person at trial in June. This is, of course, inconsistent with what you said below. To clarify the situation, I called you again today to ask if it was possible for me to speak with Mr. Maricini. Your response was to paraphrase, well, I can paraphrase it even better.
Go fuck yourself. But go fuck yourself.
She said, no, we are not willing to cooperate with you. In light of that response, I want to make two things clear. One, if Mr. Maricini intends to testify at trial, then I have an absolute right to know this, and I have a right to interview him. That interview can be done informally in a phone call, or it can be done formally in a deposition. Either way, refusing to cooperate is not an available option if Mr. Maricini wants to participate as a trial witness. On the phone, you suggested Mr. Maricini may just show up at trial rather than participating as a subpoenaed witness. He would simply choose to be there either as a spectator or as a non-subpoenaed witness. If that is his plan, I need to be clear about our position. If Mr. Maricini shows up as either a spectator or a non-subpoenaed witness, Laura will ask the Phoenix police to have Mr. Maricini immediately arrested for violating the restraining order issued against him. Copies attached. In short, I agree Mr. Maricini can testify at trial without fear of arrest, provided he complies with the rules of procedure. That means, among other things, I have the right to interview him and take his deposition if necessary. If Mr. Merritt, God, this guy never stops. If Mr. Maricini does not want to comply with the procedural rules, that's 100% okay. Well, thanks for your permission there, Dingus. I'm more than happy if he wants to stay home. Of course you do. Assuming he hasn't been lawfully summoned, and he has been. But if he comes within 100 yards of Laura without being compelled to appear by valid subpoena, then he will risk arrest and prosecution for violating the restraining order. Note. Rule ER 3.4F of the Arizona Rules of Professional Conduct provides a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party. Based on this rule, I assume Mr. Woodnick has not instructed you or Mr. Maricini to refrain from speaking to me. If that has occurred, it would be a per se violation of the ethical rules. Also, and just to be clear, I am not under any circumstances suggesting Mr. Maricini should not participate in the trial if he has relevant information. All I'm saying is that if he wants to testify, he needs to do so in a manner that complies with the rules and the law. This is mandatory to ensure basic fairness on all sides. Finally, I doubt that this is final, but finally, please note that it is a felony under Arizona law for any person to unlawfully withhold testimony, to evade legal process, to appear, and or to fail to appear when legally summoned. For avoidance of any doubt, nothing in this email shall be construed as an attempt to cause Mr. Maricini to not appear. On the contrary, I would very much like him to appear, which is weird, because 2 paragraphs ago he said, I'm happy for him to stay home.
Oh, by the way, Dingus, how about your client deciding not to appear when summoned for a deposition?
Yeah, that's interesting. That should also be addressed, provided he does so in a manner that complies with the rules, including the rule that requires the prompt disclosure of the substance of his testimony, and the rule which entitles me to interview him prior to trial. If you have any questions, please let me know. And at the end of this email message, Miss, what's her name? Randy? Randy? She heard Randy. The sound effect that came out sounded like a hissing snake. That closes out all of his emails. That's what I hear when I read them anyway. All right, so this is Laura Owens in pro per. This is the order to renew domestic violence restraining order against Michael Maricini, dated. Well, I can't see the stamp date, unfortunately.
It looks like it was 2018.
Oh, 2020! Holy crap, 2020. So it doesn't expire till 2025. Oh, God. All right. And so this is the subpoena. We don't need to read that. Good Lord, it's long. Subpoena. This is the affidavit of service for subpoena. Okay. Exhibit. What is this?
That's the email chain.
This is Mike's email to David Gingras, which we have read already. I don't think we need to read it again, but this is basically Mike's statement to him saying, you know, I was going to call you, but then I didn't call you because I saw you posted all this offensive stuff about me on Twitter, but here's all the things that she did to me. This is basically a summary of what his testimony is going to be. He says he's looking forward to being in court under oath, and he'll answer any questions that he has. Those of you who have not heard this email, you can go back and watch my live stream about Mike's response. I have an entire live stream about it, so I'm not going to go over it now. Dave just sent me, by the way, a picture of the van he's renting. It's awesome. It's like a camper van. He says, I'll be serving coffee out of my camper van June 10th if anyone wants to stop by for a morning scone in Maricopa. He has this awesome air-conditioned camper van that he's turning into the Media Central van. It's going to be great.
He's missing the opportunity to do breadsticks. He's got this obsession with scones.
Well, a scone is basically a fancy breadstick. It's just a different shape. That's all. All right. Then we have an email from David to Gregg Woodnick. We've already read these. I've read these already.
It's the forward of Mike's email to Greg telling him about, I don't know if he's being represented or whatnot.
I like this part. He's apparently unhappy about something I tweeted yesterday, which I removed after seeing his email. This doesn't seem fair. Laura is being attacked relentlessly on a daily, virtually constant basis by people on Clayton's side. But somehow, if I say or do anything to respond, this is somehow deemed outrageous. It's really frustrating. There are two sides to the story here, and one side seems to be monopolizing the narrative, often with less than total candor. Well, you know, it's not our fault that you're doing a shitty PR job, David. It's not our fault that you can't get your message out there without offending everyone and pissing off, potential witnesses. A witness who, by the way, wasn't going to testify until you did that. Wow.
And calling him a liar and fabricating her medical records. I mean...
Yeah, I don't know why he went after Michael Maricini, because we weren't even talking about Michael, right? We were talking about Clayton and Laura and what Laura's done in this case.
A little bit of Gregg,
he goes after Michael Maricini out of the blue and caused him to turn his laptop over to an expert. Like, well done, David. Well done. Good job. I love this. Anyway, I want to keep the lines of communication open with you. And I promise to keep things on the same professional level as the conversation yesterday. But I just need to let you know, if Mike won't speak to me, then I have to go back to my previous position. He's like Kaa from the Jungle Book. Do you remember Kaa? Do you remember Kaa with his, or maybe his name was Hiss. What was his name? The snake. Wasn't it Kaa?
I think so.
I'm going to ask the court to exclude him from the trial. That's just what the rules require here. So if Mike is willing to be flexible, then neither can I. And I hate this guy. I really do. I don't hate a lot of people, but this dude I can't stand. Again, this is not any sort of criticism directed at you. It's just hard when I'm dealing with people who demand that only their side of the story can be told. Yeah, Ka was the trust in me. Trust in me. Yeah, that's this guy with the swirling eyeballs. Don't look too closely, children. He'll eat you next.
Very biblical.
Oh, God, I can't stand this guy. Because time is so short. I need to know ASAP if Mike is standing on this position. And if he is, I will need to file another short MIL seeking to exclude him for non-disclosure. Oh, God.
You get emotion.
Here we go.
You get emotion.
I sincerely do appreciate you taking the time to talk yesterday, and I'm hopeful that if you need anything or want to talk further, you can just pick up the phone and give me a call. Yeah, it's like he wants to, it's like the guy in the Jafar movie. I'm all about Disney now, about who he wants to get in front of the Sultan so he can, he wants to make sure that he's in
Jafar.
his ear all the time. Jafar, right. So he's in his ear all the time so he can make sure the Sultan is under his spell. This is what he does with these phones. I want to get on the phone. Just pick up the phone. Just call me. So
Woodnick's compromised. He had a phone call with Dingus.
Those direct conversations are so helpful. Emails just don't have the same benefits. Yeah, he can't work his gaslighting magic madness with whatever hypnosis he's using with his voice over the phone. Damn. All right, let's keep going. We're never going to get to those text messages, are we? All right. David, this is...
So this is David's inline reply to an email that Gregg sent. All of the ones with numbers are Gregg's points, and then David responds in the big paragraph blocks.
All right, so you read Woodnick, and I will read Dingus.
Video testimony. I agree that all witnesses, not parties, can appear virtually if they are not local. It seems to work well with bench trials. To be clear, we are not stipulating to the admission of your expert's report, but his testimony can certainly be done via video.
My preference is to have everyone testify in person, if possible. Yeah, so we can do the hypnosis thing on them. But I'm just not 100% sure about Dr. Medshell's travel plans. He lived in Phoenix for the last 30 plus years and just recently retired and moved to Florida, but he has family here in Arizona and he comes here regularly. Given a choice, I'd like him to appear personally at trial, but if he can't make it, I guess video will be fine, assuming the court allows it. I don't object to you calling anyone by video, but again, I don't know Judge Mata's policy on this stuff, which is why I asked. To the extent it matters, I'll stipulate a video if you want it.
Trial time. I will streamline my presentation to fit into our allotted hour. Laura invoked Rule 2 with one of her prior lawyers. Maybe we can maximize our court time if we stipulate to proceeding without Rule 2. I think that also helps keep costs down.
I always favor streamlining and simplification. But we need to follow the rules of evidence, so I won't agree to waive Rule 2. That just isn't appropriate in light of the allegations here. There is way too much inappropriate stuff being brought in by your side. So we need the evidentiary rules to help narrow things down or slow them down. No, I mean narrow them down.
Witnesses. Matt, Mike, and Greg would, time permitting and consistent with disclosure, will testify that they experienced false pregnancy claims, altered medical records, suicidal threats of breakups, behavior with their families, and abortions contingent on relationship contracts, etc.
There goes our monetization. Yeah. Quite a sentence. It had like 5 things in it we can't say on YouTube. All right, go ahead.
Our disclosure statement is reattached for your convenience and includes a summary of their testimony. I am not sure what happened with your call with Randy, but she likely did not recognize your name, as you are not the first attorney Laura has had in this melee.
Melee.
I have spoken to her, but it was months ago and before your involvement. I have confirmation that Mike fully supports this case. I, of course, can subpoena him, but that won't be necessary. If you call Lori Ford, she will confirm what happened with Mr. Mulvey. I sent Greg Gillespie your contact information, so hopefully you connected. If you feel you need more information per Rule 49J, that is not included in the attached, let me know.
Just FYI, based on the comments above, I'm going to file a motion in limine to preclude the testimony of Matt, Mike, and Greg. This is classic prior bad act evidence that is not admissible under 404B. In addition, you have never disclosed the substance of any of these people's expected testimony, and it's clear you've had that information for more than 30 days ago. So the MIL will argue both 404B and untimely disclosure, and frankly relevance. An unproven allegation from an angry ex-boyfriend is literally meaningless in this situation.
Experts and doctors. I forwarded your experts draft to our experts. I am a little confused by your expert report, and while ours, forthcoming, will certainly not align and was delayed because we are giving Planned Parenthood a second chance in providing the ultrasound, I don't think your doctor's testimony, if accepted by the court, addresses the fundamental problem with your client's behavior on the litigation. Once we receive the final version, we'll be making specific content objections permitted by law. I am not going to engage in debate over the facts, as we can do that in court or with a mediator, as was previously suggested. Parenthetically, I would point out that your theory about weight gain is quickly refuted by your client's own medical records. Per her banner record, she weighed 121 pounds on June 1st, 2023.
I just got a hilarious text message from Alex, my cousin. She goes, if he quotes 404B one more time, I'm going to lose it. And I laughed, and she goes, it's like the only law word he knows. I am hoping hoping to get you MedChill's final report today, and this will include more information that you don't yet have, such as an affidavit that Laura gave to MedChill, as well as my cover letter to him, which explains the scope of the testimony I asked for, as well as some specific questions I asked him to consider. You obviously need that additional information to provide context. So this will be sent to you today, if possible. Since I don't have your expert reports, I can't really speculate about what they're going to say, but based on the limited info in your third disclosure statement, I'm probably going to bring a motion to exclude your experts based on 702 Daubert and relevance. I'll let you know once I see the reports and have a chance to discuss them with Dr. MedChill. The hell is going on outside? There's some kind of... Oh, it's a dump truck. It's a dump truck. My neighbor's getting a dirt delivery or something.
No, they're coming to pick up your dingus motions.
Sheila says, the emphasis on the S is irritating my ear infection. I'm sorry, but I can't help myself. It's how I read it in my head. It's just coming out that way because he sounds like a snake to me. Side note, your third disclosure statement says Dr. Deans is going to testify that HCG tests were never dispositive of pregnancy. Assuming she says this, which is hardly a contested issue, I think it's important to remind you that you are applying exactly the wrong standard here. Oh, welcome to David Dingus's Law-splaining 101 class. The only remaining issue is whether Laura should be sanctioned for bringing a claim she knew was false. While you are going to lose that argument for other reasons, to obtain sanctions you seem to believe that Laura has some obligation to show a 100.000000000% degree of medical certainty that she was pregnant. This is what the JFC crew has been claiming for weeks. This is exactly backwards. Laura simply has to show that she had some reason to think she might be pregnant. If she had that basis, she cannot be sanctioned even if her belief was wrong. At no point is she obligated to establish the pregnancy was confirmed in some dispositive manner, whatever that even means. This is just another reason why I will probably move to exclude Dr. Deans' testimony about HCG not being dispositive. Who cares? That is simply not relevant to any issue in this case, honestly. I'm guessing Dr. Deans would agree that a positive HCG test does give a woman a reason to believe she was probably pregnant, which would make her a strong witness for Laura's side. I guess I'll ask her when I see her report.
Motion for judgment on pleadings and intention to file for sanctions against me personally. If this is how you choose to litigate and to relitigate things that have already been addressed and denied, then a phone call to discuss is not going to impact anything. It will be more posturing, and I don't think it helps. It is helping our clients. File what you must, and we will respond in kind.
I don't understand what you mean by this. Things that have already been addressed and denied. You don't? You don't know what...
Denied! Sit down!
You don't know all your motions that were denied? Because there's been a lot.
In addition to Lexi's motions and Corey's motions.
Right.
And...
all that shit was denied. Then a phone call... Or wait. I think you must be referring to the fact that Laura's prior counsel asked the court to dismiss the case, and then the judge apparently granted that, and then changed her mind. I'm not aware that she granted that at any time.
It was the beginning of February, and it was like she had said she granted it and then pulled it, and because there were conflicting thoughts on it, they asked about it at the status conference, and she said, no, I meant to continue with the paternity action. It is not dismissed.
Okay. Yeah, parcel tongue. That's what he's speaking is parcel tongue. That's correct. Slithering. Those are two completely different issues. My motion for judgment on the pleadings is going to argue that you cannot get sanctions as a matter of law because you didn't follow the rules. I don't believe that that issue was fully raised before, which is why I'm going to raise it now. As for the ARS 12349 issue, that pretty much speaks for itself.
You gotta look at locals.
Oh, okay, wait. That means I have to in small in this for a second. Hold on. Me reading as David Dingus. This is fantastic. Oh, locals. You kill me. Look at the snakes in the hair. Snakes. I love this.
Snakes in the hair, snake skin.
This is fantastic. I
Thank
also
you,
like
Rogue
the
Mama.
snake wrapped around the throat here. This is like throat baby snakes. Hilarious. That throat looks very pregnant, by the way. Very pregnant throat. All right, let's see. I'm glad to see Locals is jumping on the meme bandwagon again. We've had a lot of, I don't know if you guys are getting lazy over there or what. Not a whole lot of memes coming through on Locals these days.
Well, if somebody would stream, then we would have content.
I know. I've had some problems though, Brad. Life.
We all have
sometimes-
problems.
Life interrupts. I don't know what to tell you. All right, let's see.
Meet and confer.
Oh yeah.
The purpose of a meet and confer is to discuss possible resolution of issues. If you have a proposed settlement you would like to discuss over the phone, I'm happy to coordinate a call, but I am not invested in a scorched earth Conor McGregor stuff. You apologized previously, but reverted to the same behavior online via Twitter and your blog. If you really think a call would be productive, I'm happy to coordinate it, but your mind seems very made up, at least from your blogs and whatnot. If you think a call would change your perspective about what you're going to file, I will find the time to talk to you this afternoon.
Oh, you're going to do it, Dave? Are you going to read it? You're going to read the email? Because it's very relevant now. He's made it relevant, hasn't he? Because look at this next sentence. Did Dave Neal ever share that long email I sent? Yeah, didn't he tell you not to share it? And now he's offended that you haven't shared it. Dave, I was going to text you earlier and be like, tick, tick, clock is ticking. Let's go. Let's share it. Let's do it. Especially because there's that hilarious glamour shot of him that he embedded in the email. Yeah, of course I want to read it with you, but I don't think I can tonight. I'm going to go on a date with my husband, but I would love to hear you read it. And you should definitely do it. And I would love to join you, but I can't. I gotta go do the romance thing. So, which I am not upset about at all. I'm actually thrilled. But let's go. I'm going out to dinner with my honey. We may get some breadsticks. So send that breadstick money, because I'm gonna go out and have a good time tonight. I'm gonna be throwing them back one after the next. We're gonna go order that big bowl of pasta, probably. I don't know, some appetizers. We'll probably go walk by the lake and have a beer, listen to some live music. It's gonna be amazing. So, yeah. Wait, what do you mean Dave wants my attention? I just gave Dave my attention. Does he need more attention? Dave, do you need more attention? Do you want to come in here?
Yeah,
Dave,
come on in.
do you want to get in here? Are you streaming or not streaming? Hold on. Dave, I'll send it to you on Twitter. If you want to pop in here and have anything to say. Hey, can we read it right now?
Oh.
That would be fun.
I might not be around when you get to it. He's doing an interview right now.
Oh, dang.
Get to the part where Bringus brings me up. I think it's time I'll share my email from Gringus. Grinch Chris.
Yeah, I knew it. I knew he was going to do. I had a feeling that he was going to, Oh, he said he can come in for 5. Okay, well, I sent it to you on Twitter. So you can pop in and tease that for a while, because can we maybe show the picture right now? Because that would just make my day. Since I can't make it with you tonight, can we show the glamour shot that he included? the glamour shot of him surrounded by cameras. Dave, can we please, 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 I beg you, in the name of all that is holy, can we just show the photo? Because damn, son, this dude sent Dave like a date, please date me email. Like, look at my good side. Look at me under the good lights. Look at how I look. Oh, Dave, please. He's not gone. He just texted me. He said he's going to pop in for 5 minutes. So when he gets here, I'm going to beg him.
He's got to do his thing.
All right.
I can't sub for Megan. Our evening is busy tonight as well.
Did Dave Neal ever share that long email I sent? If you haven't seen it, let me know and I'm happy to share it with you. The point is, you misunderstood what I meant about Conor McGregor. As I explained to Dave Neal in great detail, I may add. Great, cringeworthy, embarrassing detail. And I can't believe this guy sent this email. You guys, I can't. I have been wanting to read it to you for so long, ever since Dave sent it to me, and I had to keep my trap shut because, you know, I respect people when they say don't read this. I have been wanting to read it to you so badly. All right, here he is.
What's up?
Absolutely.
Come on, Dave.
Not driving.
Can we please just share just the photograph as a teaser? Can we share that glamour shot of David that he sent to you trying to, I don't know, woo you into a relationship?
You're like a dog that hasn't been fed in 2 weeks. Chomping at the bit. Yes, feel free to share it.
Good. All right, well, that means I have to go find it, though. It could be buried.
I don't want to tease. I want to do a pre-tease. The information I told Meg today, without saying what it is, how massive is that?
It's pretty good. It's the biggest thing to happen in this case. And look at how happy Dave...
thing?
Yeah, look at how happy Dave looks. By the way, just take a look at Dave's face right now because that's pure joy.
Yeah.
It's pure joy, and he has every right to feel that way because there has been a massive happening, like an earthquake, that you guys don't know about yet.
You know what I did when I found out this new information? I'm not kidding. I went into the other room where my wife was breastfeeding, and I just started flexing. I just started going, do you know who you married? I was just like, dang, it's some big news.
It's big.
More on that to come.
It's big.
So
it's very big.
I'm going to do some non-cleats and stuff right now, some Driving with Dave podcast interviews. But I'm probably going to come back and discuss that on Patreon, but then I'll maybe read the live this afternoon. I don't know if you're around for that, but maybe I'll do it this afternoon.
She wants to frolic in the sun like some weirdo.
No, I do. I want it. Well, but if Dave is going to have a live, I don't have to have a live from my office. I can do it outside. I can be outside in the sun. I can call in from my phone.
Yeah, and no pressure.
No, but I let me know what time if it's in the afternoon, I can probably make it. If it's the evening, I'll be out because I'm doing date night stuff.
The type of so obviously we know yesterday's motion or whatever. Her attorney Gingras gave some bizarre hypothetical about what if Clayton R-worded 3 women, right? Just some bizarre, just to like get it in there, just a bizarre hypothetical. Well, you're just seeing these tactics he's using. Like the email to me said, like, I'm going to ask that you don't share this yet. It's like, what school did he go to learn these like manipulation tactics?
I don't know, but it kind of worked on you, though. You didn't share it. And I thought, I personally would have shared it immediately. Not that I'm criticizing you, but...
No, for me, it's been in my back pocket as like, I don't need to share it, but now it's like, all right, here it is. Kind of like we didn't share some other documents that proved her wrong right away. It's just like, I mean, yeah. I was actually going to wait until June 10th to share it the morning of the trial from my cargo van, other things. But I plan on trying to get an interview with Gingras, and I will have breadsticks on behalf of my community as a donation to him. And a nice little, I'm going to hand wrap each breadstick for him, just so he can have a morsel of the windfall that comes to our community.
Well, everybody is entitled to getting breadsticks. You know, breadsticks are for everyone. We're no respecter of breadsticks. You can have a breadstick too, David.
I'm very social with my breadsticks. I believe that I can spread the wealth accordingly. I have a marginal breadstick tax I like to do, and I've received more than my fair share of carbohydrates, and I'm willing to give 100% of additional carbs to anybody that needs them. June 10th.
You got to make sure to write on the bag, do not give to Laura. She might gain 13 pounds and look pregnant.
Dave, did you notice that I papered my wall with David Gingris's filings? This wasn't even one filing, by the way. Just one filing, and my wall started rejecting them. The wall started throwing them off onto the floor.
Yeah, we need to get you sponsored by like HP printer ink or something.
Yeah, I'm gonna need it.
Just to be careful, I do want Jane Doe to know that breadsticks are not meant to be swallowed. I just want her to know, because I know what they look like, but just you got to chew on them.
You have to chew them first. Yes.
Chew the breadsticks. Just a PSA from friendly Dave over here. I don't want anyone to swallow a couple of loads of carbs.
Well, that was very kind of you. It's good that Dave's here to give us those public service announcements. We need them. I can't find the email. God dang it, Dave.
Oh, man.
It's buried in here somewhere.
Someone in my Patreon superimposed Gingris's face on the Tiger King, and I can't not see him as the Tiger. Him and Jane Doe are the Tiger King, and then whatever that crazy what's that neighbor's name? The crazy lady.
Carol Baskin.
Yeah, Baskin.
Carol Baskin. They're quite the duo, those two.
Oh yeah, for sure.
Somebody asked me. They said, "Why do you think Gingras has such an infatuation with you?" And I think it's because I make more money than he does. I think like he's got some weird thing, like he did it the right way, so he should be having the success that I have. I don't know.
We speculated on MG Law Stream last night that he was paid up front, and then he's getting a sizable compensation if, for whatever reason, there's something awarded in her favor, or if they do settle for some amount of money.
You know what's interesting? I don't know if you got to this part yet, but when he talked about a settlement, in this document, in the emails, you can see he actually says he would reject an offer for Clayton to pay her $1 million.
Right.
Yeah.
But then he also said in like 2 motions ago that he was going to request like $140 million for defamation.
I mean, based on the new information I got today, I don't think they're going to have much of a case, because the army is growing. But what can you say, you know? Oh boy, funny times. Well, look, I don't want to stop your flow. I was enjoying. Oh, my hair is looking great today, but I just caught a wind.
Oh my goodness, you've got the kind
Dave
of waves.
got the bonnet.
You've got the waves like I do. Look at that.
Oh, wait,
the waves.
Long lost siblings, I guess.
I know. You've got those good waves and curls. I didn't even notice that before, but look at that.
Well, ever since you called me out for aging too quickly, I decided to increase my. I bought rose hip oil in bulk. I've just been misting my face every day,
slathering it on.
Tin Man. I just get all the joints and I just keep it going.
The same thing happened to you, though. As soon as your first kid comes, you start getting gray in your beard.
This girl.
Oh no, we're losing Dave. Wait, we lost you for a second.
You lost me.
You're back.
Here. I'm setting up my cameras for my interview today. Got to stay busy.
Well, good luck on your Driving with Dave videos are always a lot of fun. Everybody needs to get over and subscribe to Dave's Driving with Dave channel too. You have like a separate channel for that. What's it called?
It's called the Dave Neal Show.
Dave Neal Show.
That's not my audio. It was a channel that blew up during the Johnny Depp trial, but I stopped doing it because the Johnny Depp trial, like once it was over, I had these 50,000 fans that didn't want to watch there was nothing left to cover. So I kind of buried this channel and I brought it back to do interviews.
Nice. Yeah, so you guys need to get over there and subscribe to the Dave Neal Show as well as his other YouTube channel, which I believe is just called Dave Neal. Isn't that one just at Dave Neal?
That's right. But anyhow, you guys are doing great work, so I'll let you go. But I'll let you know. Do you want me to forward you that email? So
if you can find it, that would be great. I just found my very first email to you on January 7th. We're going to put this one in the baby scrapbook, when we make the scrapbook of this. This is going in the scrapbook for the very first contact I had with Dave Neal, January 6th. Who knew that we would redeem January 6th? Look at us redeeming January 6th.
Oh, boy. Anyhow, it's a
YouTube insurrection.
Dude, his phone is rejecting him.
I promise.
Your phone is staging an insurrection right now.
All right. I'm going to go storm the Capitol of this interview.
All right.
I'll talk to you guys later.
See ya.
Bye.
All right. Yeah, I did. I just found our first communication. I reached out to him on January 6th of this year. And that's funny. I'll have to read that sometime. All right. So hopefully he'll forward me that. It's like right around April. I think it was in April when this happened. I'm still kind of looking for it. Dang. Man. It's too bad I don't know exactly where it is or what date this happened.
I mean, honestly, if you just do a from search from Dave and then search Gingras, it's got to be any time between late March to now.
It's got to be April. I think it happened in April.
I think it was middle to late April or middle to late March.
It wouldn't be March. It was before April 22nd because April 22nd is the email we're reading right now.
Right.
And so he's saying to Greg on April 22nd, didn't you get that email that I sent to Dave? So it has to be before then. It has to be before that. Oh my gosh, there's been so much craziness. There are so many emails between me and Dave. It's not even funny. This could be it. No, that's not it either.
So March 26th is when Gingras came on.
Oh, he resent it. Okay. All right, we have it. All right, so I have permission to just share the ridiculous picture. I like to call it a
Glamour shot.
Glamour shot. Are you ready for this? How do I make it bigger? I gotta make it big.
Embiggen.
Is it image 2? No, it's not image 2. It's there it is. Oh, it's a little blurry. That's unfortunate. It shows up better when it's all right, here we go.
Well, now you have the timestamp to
smaller. All right, are you ready for this, folks?
Let's see.
Because here it comes. David Gingras sending this was literally in the body of the email he sent Dave as like a look at how handsome I am.
It looks like Laura's promotional image.
Look at this. You've got to be kidding me. He's like, look how important I am. Look how important I am. Dave says I can share an excerpt or two.
Oh no.
All right. Well, I'm going to share my favorite one. Look at this, though. Look at this douchebag. And people ask me, why do I call him a douche canoe? Exactly this. This is it right here. Let me read.
Now, wait a second. I've seen his profile photo on X, and that hair does not match the hair on X.
Well, he was probably using hair color. This was some Netflix documentary he said he was being filmed for that I don't think ever came out. 2 random paragraphs. Okay, Dave just said I can share 2 random paragraphs. I already have one all picked out.
Do we need a dice roller for randomness?
I think the one I want to read is his bragging about meeting Colin Farrell.
Oh God, why? Why
Okay,
would
so
you...
here's what he said about the picture of himself, like that I just showed you. Let's see. The case was such big news that I had a film crew following me around in my house, office, in court with my permission. They filmed me for weeks to cover the story. I still have some of this video if you want to see it. I eventually flew to New York City to take Colin Farrell's deposition. He hated me. No shit. We all do. That's really how everyone feels about you,
Seems
David.
to follow you.
My client leaked some information about the case to the media, and Farrell thought incorrectly that I was the leaker. Sure. My response, this is your deposition, Mr. Farrell, not mine. I am the one who gets to ask questions here, not you. Reading that back all these years later, maybe I am a douche canoe. I should have been nicer to Colin. And then he goes and he posts a photograph of Colin Farrell that he says he took with his client. And he says, I personally took that photo, and I think Colin wanted to reach through the camera and punch me. Just look at him. The vibe is so hostile. Now, I'm going to show you this photograph, and then that's it. You're going to have to tune into Dave later on for the rest of it, because that's all I'm going to share. I'm going to show you this photograph, and you tell me if Colin Farrell looks anything but like this is just his normal face when he is asked to take a picture. Does he look like he's ready to punch anyone in the face?
No.
Honestly, I ask you. He looks kind of fine to me. Why would he send this to Dave? Because he's a douche canoe and he loves to toot his own horn and talk about himself, and he also has a crush on Dave. He wants Dave he wants to file a motion to compel Dave to date him. I don't know.
It's like he's trying to out-celebrity Dave.
Oh, maybe that's what this is about. Oh my God, Brad, you hit on it.
Ooh.
Dave has like connections in, the Bachelor world, ABC world. He has these minor celebrities on with him all the time. He's kind of in that entertainment space.
In addition to being a comedian.
Yeah, David Gingras thinks that he needs to out celebrity him. And he thinks that this is going to impress Dave. That somehow his connections to these Hollywood people, even though they hate him or whatever, are going to somehow impress Dave. Yeah, I do think he's jealous of Dave. I do. I also think he might want to put his tongue on him. I don't know. It's weird.
I don't get to hang out with bachelors. I just have to depose celebrities that hate me.
Yeah, everybody hates him, and he thinks that that's, I don't know, fun, that's a fun fact about him that he's sharing. You guys, this whole email is as crazy as that. It's as crazy as that. There's nothing not entertaining about this email, I'll tell you that much. All right, let's go back to finishing this reading, and then I want to get out of here. All right. As I explained to Dave Neal, I have been involved in many cases that were much more contentious than this one, and in many of those cases, opposing counsel ended up losing their licenses. And in more than one case, the lawyers ended up in jail. All right, that's it. I've had enough. I was debating whether or not I should do this, and now I'm going to. I am going to send him a press inquiry. David@gingraslaw.com. It's time. I've had enough of this shit. David.
You pissed off the wrong woman, Dave.
@gingraslaw.com. Press inquiry. Dear Mr. Gingras, Esquire. I am writing to you to ask for your comment. No, that's not what I'm doing. I'm following up on an exhibit in Gregg Woodnick's recent filing. That was an email from you to him claiming that attorneys you opposed in other cases have either been, did he say disbarred or disciplined? Oop, there goes another one of his motions off my wall.
Denied. Sit down.
Was it disbarred or disciplined? Which one? Disciplined or disbarred?
I think it's
Wait, hold
both,
on.
but you scrolled up way too far.
I scrolled up. Okay. Here it is. Losing their licenses. Okay.
Yeah, disbarred and
opposed in
ending
other
up in
cases
jail.
Have lost their licenses and or ended up in jail.
I just want to point out, you've been relenting that you haven't received a letter from Laura or Dingus, and
I know,
now you're intentional.
I'm asking for it. Okay,
Yeah.
here we go. Ended up in jail. Please respond with the identifying names of those lawyers and the cases and case numbers in which these alleged events occurred. In order to report these new statements you've made, I need to do my due diligence. Why can't I spell diligence? That's right. No, I guess it's not right. Okay, there we go. Diligence and fact check those remarks. All the best.
Oh no.
All the best. All right, let's just read through that again. Dear Mr. Gingras Esquire, I'm following up on an exhibit in Gregg Woodnick's recent filing that was an email from you to him claiming that attorneys you opposed in other cases have lost their licenses and or ended up in jail. Please respond with the identifying names of those lawyers and the cases and the case numbers in which these alleged events occurred. In order to report these new statements you've made, I need to do my due diligence and fact check those remarks. All the best. All the best. Yeah, sounds good. Send. All right. That's out of here. I'm sorry, but that's an unbelievable claim he's making. Judges very rarely send attorneys to jail. Yeah. No. Like, if that happened, it's public record. Let's have the cases. Let's have the names. Let's go. Let's go, Dingus. Let's go.
He's not watching because he said he's preoccupied with some family emergency, which we don't want anything to happen to his family.
Course not. I hope his family is doing okay, and I hope it all gets worked out. But I would like him to verify that those statements he just made are actually true. Because I think it was him just the other day who said it's against the rules for lawyers to ever lie. So I'm sure that this is not a lie. And because it's not a lie, he will have the evidence to back it up. Right?
And God forbid it's not something where the other lawyer did something in the case that he was on the opposing counsel for, and then he's taking credit for getting them debarred.
Uh-huh. Right. Exactly. Aussie Wombat, thanks for the 2, says, love your streams, hate douche canoe more. Okay. Unhung Hero, thanks for the 2, says, maps and dingus motions go on the wall. That's right, they go on the wall. Trina9852, thanks for the 5, says, why is her lawyer called Douche Canoe? What lawyers are for who I get confused with all the names? Can you please play the new song from yesterday?
Oh,
okay,
no.
Oops.
That may be the outro song.
We call, I call him Douche Canoe because they were calling Laura Owens Jane Doe for a long time, and her initials were JD. So when he came on the scene, I didn't think it was a good idea for us to give him all this free publicity, so maybe we should call him John Doe. But John Doe just wasn't fitting enough, so I decided to call him John Douche Canoe instead, to keep the same initials. And it just kind of stuck, John Douche Canoe Esquire. All right, and can I play the song from yesterday? Yes, I can. And thanks for sending the super chat. If you send super chats and ask me to play songs, guess what? I play them. So let's find it. Would be in my video file.
Do you want a phone call?
And this is a partially fan made. It's a collaboration between me and Frank. Frank, who's one of our listeners here, watchers here. He made half of the song. I made the other half, and then I made the video for it. And it's a thing of beauty, you guys. A thing of beauty. But I can't remember what I called it. What did I call it? Ah, do you want to have a phone call? Here it is.
Woodnick, do you wanna have a phone call? Come on and call me. I never hear from you anymore. Come on the line, it's like you're ignoring me. We need to talk off the record, and now we're not. I wish you would tell me why. Do you wanna have a phone call? It doesn't have to be a phone call. Go away, Chingrass. Okay, bye. Do you wanna have a phone call? Or go out to lunch in the garden? I think a phone call is overdue. I've started talking to the blog on the internet. Hang in there, Laura Owens. It gets a little messy, all this fake evidence. Just watching the hours tick by. Chingrass, please, I know you're in the office. People are asking why I'm still on the case. They say I'm a douche canoe, and I'm an
idiot. God, I love this song.
Just give me a call.
I want to know what the thematic pieces are.
It's about the
case. What are we gonna do?
Do you want to have a phone call? Do you want to have a phone call?
God, it's so good. It's so musical.
Come on and call me. I never hear from you anymore. Come on the line. It's like you're ignoring me. We need to talk off the record, and now we're not. I wish you would tell me why. Do you want to have a phone call? It doesn't have to be a phone call. Go away, Chingrass.
Okay, bye.
But don't forget, I could have you arrested with the cops. Don't avoid me like some kind of snob. You'll regret it if you do. Don't say
I ever threatened you.
Do you wanna have a phone call? Just say you'll talk to me. I'm really just a lonely guy, and I need to make you see. Okay, bye.
So good. It's good stuff.
It is really good.
So good. I love it so much. All right, let's get back to the super chats. Where was I? Sarah Adams, thanks for the 2, says, for your first snake reading, I am impressed. Aussie Wombat, thanks for the 3, says, I really need a phone call. I really need a phone call. He's creepy. Linz, thanks for the 2, says, if MM appears under subpoena, would it something 100
Basically,
yards?
would it be violating the 100 yards
No.
restriction?
No. If he's there under subpoena, he has every right to be there. And a courtroom, by the way, is a neutral space, and no restraining orders should apply if you're in court. It just is stupid.
Even if you're there for another matter, you
should be fine.
Yeah.
Yeah. Julio, thanks for the super chat, says, I thought I canceled you. Yeah, right? I know you were supposed to, but I guess you're back. Chris Jenner, thanks for the 2, says, I love Gingras and can't wait to meet him. Well, you're the only one.
Yeah.
But I'm glad he has a fan. Everybody deserves one fan. Sarah Adams says, Tupac can show up without reason. LOL. Chris Rowland, Thanks for the cheer. Says, thanks for being you, Megan. Saturday is 6 years clean. Well, congratulations to you, Chris. That's awesome. Good for you. I love that. All right. Let's try and get through this because I really want out of here. I really do. I love you guys, but I want to go outside and dig around in my garden for a while. All right. The Conor McGregor reference simply means that I've been dragged into a lot of really nasty fights. Never by my choice. Oh, sure. Sure. And in many of those fights, my adversaries have ended up self-destructing, while I'm still here standing. That's what Conor McGregor means to me. It was never a suggestion that I enjoy violent confrontation or that I am out to gratuitously hurt anyone. No, that would be ridiculous. My point was to say that I'm a veteran of many tough battles. And while I would prefer to avoid messy conflicts, I am not afraid of going there if given no other choice. Having said that, I do think we should talk because there are so many moving parts here, among other things. I just want to get a clear understanding of who is really coming to trial and what they are going to say, bearing in mind I'm still going to seek to exclude pretty much all your witnesses.
Yeah, and all your evidence.
Based on a lack of timely disclosure, it's hard to have that conversation via email, and yes, I'm more than happy to give you a verbal summary of everything on my side as well. Speaking of which, now that I fully understand the case from Laura's side...
I still don't think you do.
Yeah, I would really find it helpful if you could give me additional detail from Clayton's side, especially with regard to this claim that Laura faked pregnancies with other men. Let me give you an example. In talking to Laura about all this, I asked her to explain the story of Gillespie. I was curious to know exactly what basis he had for claiming that she faked being pregnant. Laura's response was paraphrased. She had a brief relationship with Gillespie. I think she said they had sex twice and went on like roughly 6 dates over a period of a few weeks. Laura tested positive for pregnancy. Gillespie asked her to terminate the pregnancy medically, which she did about 4 weeks later by taking pills in Gillespie's presence. According to Laura, that's the entire story, aside from the later litigation, which went nowhere. There was never any ultrasound. Why would there be? And there were basically no other medical records involved other than the initial pregnancy test and the later medical abortion. Bullshit. And this is where we are going to flip over to Reddit, because Reddit has done some good work as usual. And we are going to get to these text messages. Brad, I'm going to require you to read the part of Gregg Gillespie.
Of course.
And I think we can get through these in a relatively short period of time. And when I mean relatively short, I mean probably the next hour. So let's just hurry this along now, shall we?
Got to get ready for Angry Brad.
All right, here we go. All right, let's share this. Yes, doggy. You just get all that. What is he shaking off? What's the dog shaking off? Was he outside in the rain?
No, she just woke up, but she's been hearing the lawnmower next door.
Perfect. Where's the Reddit tab? Ah, there it is. Okay. I have too many tabs open, as usual. Brad is not surprised by that at all.
Nope.
Okay, let's go to the beginning. So Reddit has created a thread of these text messages. Brad, can you see them okay? I'm going to try and... Let's make us... No, that's going to make it worse. How about this?
Share the thread with me and I'll pull it up on my side.
Okay. Yeah, that way you don't have to... You can read along. It's in the private chat for you. Dropping it now. There you go. All right, I will be reading the part of Laura Owens in this text exchange. Now, remember, these are the text messages between Laura and Gregg Gillespie. Let us please try to remember that Laura's lawyer just said there was no sonogram. She never got one. That she immediately took abortion pills and just got rid of this alleged pregnancy. And that Gregg has no evidence that she faked anything. Are you ready, Brad?
I am ready.
All right, here we go.
Oh. Okay, I haven't had any bleeding yet. I'm feeling so sick from these pills. This is so traumatic knowing what is going on right now in my body. I am so sad right now. Do you understand how awful this is for me right now? This is worse than the first pill. To know I'm going to physically lose the baby. Did I make a huge mistake, or are we actually going to end up together? I hate this, and this is only worth it if we end up working out. I'm so nervous about everything. This isn't even hard for you. And then he sends
her video of her standing outside of his door. And the dog, his poor little dog. I love the dog. And the dog is like, this one again? Why is she here? Like, and I'm wondering, and I don't know, I'm going to have to see if I can find out if she was, what is that noise? Oh, it's the lawnmower. It's the lawnmower. I have to ask if these were sent at the exact same time that she was standing outside. I don't know. It appears that way, that she's standing outside and sending these text messages, and he's in the house watching her and filming her, which is really weird. But okay. So here we go. So he sends her one video and one picture of the dog watching her texting from the window. And then he sends her the Vanishing Twins sonogram from the blog spot from the woman that she stole the sonogram from. So let's move to the next one. We have a close-up of her basically stalking him. And here's what she says next.
Based on your behavior the last 2 nights, I have no reason to believe you said you wanted to be with me, except for that you were manipulating me into getting an abortion, and I definitely shouldn't be reaching out. You have been very cruel, and I'm guessing you're embarrassed. As mad as I am, I keep thinking back to my gut feeling about you and why I did this in the first place. I don't believe this is who you are at all, nor who you would want to be with me without this as a factor. Same goes for me. I missed 2 interviews this morning, which has never happened. And I am trying to go to the doctor because I feel awful. My dad got taken into surgery early, so that may not happen until later. It feels very lonely right now. I will never be spoken to the way that you have talked to me recently. If I've totally mischaracterized you, and this is who you are, or if I would bring this side out in you outside this specific situation, you need to tell me. I had to base the biggest decision of my life on who I thought you were on 4 dates and saw something very special. If you always think of me as the girl you had an unplanned pregnancy with and won't be able to view me differently, it doesn't continue.
Okay. Now this is on her side. She sends on August 6, 2021 at 8:24 p.m. this picture of this sonogram. This is the Fiverr one, folks. You can see it from here. You can see the Fiverr from here. I can see it from here. Here she goes. Again, keep in mind, this is the same relationship that David Dingus claims there was no sonogram involved. Just remember. Let me read that back to you again. Let me go back to the filing. According to Laura, that is the entire story. There was never any ultrasound. Why would there be? Yeah. Okay, let's...
So read that second paragraph down to go to Sedona and then continue on the next one.
Where do you see...
I still want to believe.
Are we not on the right
side?
On the right side?
Yeah.
So this is going right to left?
No, I'm saying the next image is I still want you to believe you're the guy.
Oh, I should go to the next one first?
No. Read this one, go and read down to go to Sedona, and then continue on the next image.
I don't see to go to Sedona on mine.
It's right there.
Are you on the... What are you talking about? I see it on this one.
Go back.
I don't see
Second paragraph, 3 lines down.
Oh.
Go.
Okay, I see what you're saying, and then switch over to the other one. Okay. So she sends him the picture of the Fiverr sonogram.
Looks like you're going to be a dad to 1 or 2 babies. was sick enough to go to the clinic this afternoon and had to get an ultrasound to make sure I wasn't having an ectopic pregnancy. I wasn't. I just found out that I'd been pregnant with twins. Looks like one of them passed or isn't doing well, probably because of the medicine I took. I had the option of a surgical abortion and elected not to. If I'm going to go through this on my own, I will let God decide if he wants both, one or none, to be born, and the kid or kids would deserve to know that their father's side of the family. I'm giving you one more shot to admit you were overwhelmed and panicked and apologize. Otherwise, you are not getting any input going forward. Your behavior is appalling, coercing me to get an abortion for your own personal agenda, and I will escalate this if I don't hear back from you. I talked to a lawyer who told me I can have a court order to establish paternity at 8 weeks. And get child support from that point on, which is 25% of your income. Even if you're making less than me, you would not get custody given all you have written about aborting the pregnancy. If you also had manipulated me to take abortion pills that resulted in the deformity or death of the second fetus, I would also pursue any and all legal action for that. If you're going to stick with manipulation, lies, and ghosting, you are not who I thought you were and would deserve it. I still want to believe that you're the guy who wanted a fresh start with me and to go to Sedona for it on a trip that you told me to book a hotel for. I told you early on that I didn't need to be with me, but you didn't need to be with me. I don't need to be with me either, but you didn't need to be with me. And that I would make the decision on my own with my own timeline. But you insisted you wanted to be with me and do this the right way in the future, which I believed. This is your last chance to show me that you weren't coercing me to have an abortion under false pretenses. I would have had the surgical abortion today if you were supporting me. I still would if you still intended to keep your word. If I don't hear from you, I'm going forward with the lawyer. Here's what I did. I made an appointment for the surgical abortion as well as one with the attorney to go over specifics. So let me know which one you want me to cancel. I guess you're right that I don't know who you are, so show me.
You're going to birth a baby with birth defects? You took pills!
I won't know until later on what the issues would be, if any. So what do you want to do? It clearly affected at least one, considering how small it is.
It's one baby.
And then
she sends a zoomed in picture of the Fiverr logo. You can't see it because we're in the wrong. Hold on. We got to move over. Look it. It's a zoomed in picture. It's a zoomed in. You can see Fiverr from here. Can you guys see it? I can see it. Look it. She sent him a zoomed in. This is the woman who's told her lawyer there was no sonogram in Greg Gillespie's case.
All I have wanted is to date without pressure. If you want to keep your word and go on dates with a good attitude, I'll drop any lawsuit for good, regardless of the outcome. This has been so much pressure on us, and I'm not trying to get you to fall in love. I just want to do everything you said you wanted without the weight of this on us, and you're right. I can't control the outcome of that, but blocking me right after is complete coercion.
So I just want to say, all I have wanted is to date without pressure, while she literally has her boot on his neck trying to get him to do everything she wants him to do.
I don't agree, Brad.
Okay.
I think he's coercing me, Brad. I don't know where you got that, Brad. I'm gonna sue you, Brad.
My pearls! Oh no.
Greg, move on.
I didn't. Goodbye. Stop contacting me and stop harassing me.
Admission of abortion coercion right there. You can't accuse me of harassment when you told me you wanted to be in Sedona today with me after you forced me to get an abortion and asked me to meet up with you yesterday for a pregnancy test. I am only contacting you to fulfill what you promised. We'll get you served tomorrow. I'm going to an urgent care now to get an ultrasound because this has pissed me off. Guessing you don't care to know, see the results since you asked me an hour ago for them. If there is, I will not be getting a surgical abortion and instead will get an order for a DNA paternity test and file for child support.
Admission where? You're a scam artist. You need to leave me alone.
Where you just wrote that you didn't intend to date me. You are so damn wrong, and we'll find out how much I'm not. You deserve as many legal issues as possible after what you did to me.
I'm sorry, but you must have read that wrong. I said I didn't, which was the... and it's gone.
It's on the next one.
Is it?
It's right here.
Oh, yeah. I didn't, which was the answer to a different question. You are clearly trying to manipulate, scam, and blackmail. Stop harassing me. Stop contacting me. Stop reaching out from different forms of communication. You need to leave me alone, Laura.
Owens. I like how it says Laura Owens. You have manipulated me, and I have not scammed or blackmailed you at all. Telling me to get an abortion for all these reasons and then blocking me, and then believing you would keep your word is harassment? You deserve to go to hell for that, not me. Let me know if you want the ultrasound results.
No, I don't want a stranger's ultrasound. You're harassing someone who's not the father of a child that may or may not exist, and you have caused punitive damages in my life by imposing threats, blackmail, and induced stress and illness on a stranger. You need to leave me alone. You need to leave me alone.
You have demanded an ultrasound as recently as this morning, and no one would say that I blackmailed you, considering I gave you every single chance to say no. And in fact, you wrote all these promises to me. There were no threats except that I would have a child that you were the father of. And no one will believe you got COVID because of me. That doesn't make any sense. The child existed. Oh my god,
It's Schrodinger's twins again. The child existed. It exists and existed at the same time.
as stated in my medical records, and you knew that.
Oh, what medical records? You mean the medical records that David Dingus says don't exist for the Greg Gillespie case? Yep.
Where was I? I've lost my place. This woman running this live stream keeps making me lose my place because she's a horrible bitch. Just saying. All I need from you is DNA, which you will have to give voluntarily or by court order. I have never been involved in any lawsuit in my life. But you have ruined my life by manipulating me into having an abortion when I did not want one, and then had the balls to now say that this is harassment. You're a 35-year-old coward. You deserve to be embarrassed after what you did to me. Can't decide if I will have a process server or the sheriff serve you at work. Probably the sheriff. Also going to email copies of the lawsuit and all documentation to your family, because you deserve to have your selfish lack of morality and consideration shown to those close to you. Just like my family knows that I had an abortion for a guy who convinced me to. Now I'm humiliated. And again, I can prove that it has been a pregnancy with your kid, so don't think that I won't be able to.
Now she's sending him the definition of verbal abuse, emotional abuse.
Here, take all of my abuse. And
Didn't realize that what you've done is technically a DV charge, but it matches up perfectly. We'll also be filing DV charges. Just a heads up.
That's like
all the best.
All the best. It's your turn, Greg.
You have performed every single one of these actions on me.
I've been pregnant, and that's provable. Your emotionally abusive actions were directly as a result of that. Which is also provable.
And it looks like medical records, which we can't see, but that's what it looks like, medical records, and
God,
another
I want
image.
those so bad.
And another image of the sonogram. I'll have to see if I can get them from Greg, maybe. All right.
Here we go. Here you go. An ultrasound and a lawsuit. I went to the ER to get an ultrasound.
Oh my God, this is a different ultrasound. This is a different one. This is not the fiber one. This is a different one we haven't seen before.
We need that one.
Oh yeah, we got to look at that one.
She didn't see a second fetus, so it's probably gone because of the abortion. The other one looks fine, but who knows how it will end up since I took the pill. Wait.
Since I took the pills last week, the chances...
Last week. The chances are better than not that it will survive, but I don't know what deformities, abnormalities there might be. How dare you call me a psychopath and a scam artist, a manipulator, a liar, and making me feel nuts for wanting a relationship with a stranger, aka a guy I had gone out with 4 times and felt a great connection with, and who convinced me he wanted all of these things if I got an abortion. You're the awful one for convincing me you liked me so much that I should give up a pregnancy now so that we could do it the right way in the future. Then you want to act like I'm harassing you for blocking and ghosting me when you made me all these promises like caring for me after this as soon as it was done. Then when I finally get in touch with you, you tell me to move on with my life? What human wouldn't be devastated? Read your text back. You promised me this great future that you had no intention of carrying out on. You were mad at me for going in circles, thinking and texting all the time, trying to make my decision, and claimed that you never changed your mind. That you wanted a great life with me. That's intentional tort. And I filed a lawsuit for $45,000 in emotional damages, emotional abuse, and coercion. I've already submitted the max of 25 pages of evidence online and paid the $330 filing fee. Your evidence of my vast amounts of text was me trying to be sure that you weren't lying about wanting this with me, all of them. The court will not think anything of being suspicious of your intentions when I clearly had my reasons. As much as he was... Oh, God, this woman...
Oh, my God, she never stops. It never stops. This goes on for pages and pages. I don't even know if I can do this with my voice anymore.
Yeah, don't forget to hit the like and subscribe, or I'm having the babies. If you don't hit like and subscribe, I'm having the babies right now. I'm going into labor this very second. As much as you would like to convince yourself that it was someone else's kid, or that I somehow convinced One Medical to falsify the results of the pregnancy test, you're wrong.
All right, so we know that she's given him a One Medical record. So there's one medical record that David says doesn't exist.
You've told me so many different stories about how you didn't want the abortion. I now have 44 messages from you telling me to do it, and contradicted yourself quite a few times about how we did or didn't have sex, or that I forced you to. Yeah, I could really physically dominate you at 5'4". And so many other ridiculous stories. I ordered a prenatal DNA test today, and if the baby is alive, you can do it. If not, your pressure killed not 1, but 2 fetuses. And when you said you wanted to talk to my exes because they would have stories, that's horribly hurtful and total bullshit. My abusive ex was stalking me when I ended it, and I had several witnesses. Besides that sociopath, none of my exes would have had a bad word to say about me.
Oh, really?
I've never filed a lawsuit before, and I definitely wouldn't if I didn't know I could win it easily. I'm giving you one final chance to redeem yourself.
Last offer, folks. It's a going out of business sale. We have another last offer.
I'm giving you one final chance to redeem yourself as a human being. Say you've had a meltdown and that you were going to keep your word. I can't get myself to believe you're really that bad. If that's the case and you really did want to keep your promise to me, I will withdraw the lawsuit tomorrow and do the surgical abortion. If you bullshitted me to kill human lives for your own selfish and cowardly benefit, I will make sure that the law makes you pay the consequences for your actions, because they are completely inexcusable. I am not the crazy one for believing you liked me. You would be a domestic abuser of the worst type for that level of manipulation. If that's what you are, the civil lawsuit stands as it has already been filed. I will file for a criminal... something... I will file for a criminal... It's down here somewhere.
What the hell? Oh, there it is. There it is.
Criminal lawsuit for your
I
actions.
will file for a
criminal lawsuit for your actions against unborn children. I will have the court order you to take a DNA test. I just took a DNA test. Keep that child if it survives and raise it in a great environment and put child support on you, and you will pay for medical expenses if there's a deformity. Don't you dare act like I'm desperate and crazy for believing your word. Let me know. Let me know what you decide to do. All the best.
Is she gaslighting him into telling on herself that she's desperate and crazy?
Pretty much. Yeah. I like how there's no response. So it goes from that to August 16th.
Hi. I'm not sure if you've seen my emails, but if not, please let me know so I can resend. I wanted to check in with you before the server tries to serve you in person for the final time. If you want to keep your original promise to me, I will keep my promise to you and have the surgical abortion this week. If not, I will continue the pregnancy, having the babies tonight. It's very easy to dismiss this pre-trial, and that is why I wanted to ask you. Please let me know so I can hold off from going to you. All the best!
All right, moving on to the next one, where it's pictures of a pregnancy HCG P-stick.
She must have stock.
From every possible angle. That's not even relevant as to why I'm doing what I'm doing, but just so you know. Okay, I guess I have my answer. Since you won't directly respond to my question, I'm planning to file for punitive damages first thing tomorrow, if we're not on the same page. So I'm presuming you're not responding means we're not, since I'm sure you've seen my messages. I'm not playing games here. I won't be ignored, Dan. I'm not playing games here, and if you want to ghost me, that's fine, but I'm moving forward. I sent you an email. Please read it. On Friday, I made an appointment for a surgical abortion this week because I want to believe the best in you and that you intend to keep your word. It's a huge deal for many reasons, and given the uncertainty of what defects it may have, I would understand your reasons for wanting me to do that. I'm definitely good not canceling it as well, and put trust in God that he wouldn't give me a child with issues that I couldn't handle. I just cannot abort past this week. It's not fair. Please let me know.
And it looks like she has shown him a screenshot of a scheduled appointment, which you can just make online, I guess.
I'm trying to give you one last chance to let me know why you wanted to meet me at 7:30 before I actually have you served. It would make this so easy to dismiss if I just chose not to have that done tomorrow. But if your lack of response means you accept the charges, my process server wants to serve tomorrow. He said he would want to serve them to whoever is above you, so I guess Cecilia? I will confirm with the company that it's okay. If you would rather someone else get served, that's fine too. Greg, I don't want to do this whole thing and get your money. I just want to be with you like you said you want. Just the two of us. Why is that hard? Why did you want to do it 7? What did you want to do at 7? I cannot sleep. Okay, this is it now. The same day at 3:48 a.m. I cannot sleep. I'm so stressed. Please, just let me know if you want me to stop what is set up for tomorrow in terms of service and filing the other lawsuit. I just want you to be who you said you were. What do you want?
August 23rd, 6:26 a.m.
Question mark, question mark. I want to cancel service and not go through with the attorney contract if you want me to, but you have to let me know now. I can't do anything about this when the court attorney's office opens. I haven't even clicked send on my contract or my response to the attorney. I sent you a copy first. Was waiting for you, and I know you read it. Where did you want to meet at 7?
August 23rd at 7:24 p.m.
Hi! I'm not contacting you in regards to the civil case. If I don't hear from you tonight, I will be filing serious criminal and DV charges tomorrow. After tonight, I won't be giving you the benefit of the doubt anymore, and I will see your promises as manipulation and coercion. This is emotional abuse, which is considered domestic violence. You know how you treated me. I will see your seriously pressuring me, use of expletives to get an abortion as anyone else would, threatening and intimidating. I will come to terms with the fact that you misrepresented yourself and were guilty of committing a fraudulent scheme. I sent you 77 pages of text messages proving I did not want to have an abortion, that you were positive that you wanted a relationship with me, offering to raise the child without your involvement. If you didn't want to be with me, you could have blocked me then. Blocking me right after shows that you had no intention of wanting what you told me you did, and that you did everything in your power to get your way, even though you knew that it would... I don't know. I believe I need to file the criminal lawsuit before I can proceed with the civil case. So please let me know who will be representing you for that. Again, you would be owed an apology and I would drop everything if you were acting with integrity and truly wanted to be with me. Please let me know what you decide, to keep your word or not. And if I don't hear from you, I will presume that you are admitting guilty and will file this report tomorrow and go full steam ahead with the criminal case.
We missed a great opportunity. I can't believe I just thought of this now. If Gingras and you keep emailing back and forth, you should take one of these lines and just put it at the bottom of your signature and just a new one each time.
So this must be her 73 pages of text messages that she claims. Oh my God, she's still going. I thought I was going to need you for this, Brad, but apparently
no, you don't.
I don't. It's just all her all the time.
9:36 p.m. August 23rd. Confirming that these messages sent the day before were fraudulent promises that you knew would cause extreme emotional distress when broken, aka DV. You are leaving me no choice but to press criminal charges. I have offered to get a surgical abortion or have a DNA paternity test. I would drop all charges if you kept your word. That's all you have to do. You must have wanted some resolution when you suggested meeting up today. I will hold off for a day on criminal and pause the civil and family if you plan to keep your word, but need a day to confirm that's what you want. Let me know.
August 24th, 12:15 a.m.
I'm in bed. Do you want me to hold off a day if you're ready, but need to gather your thoughts, or are you ready to speak to the cops already? I'm not asking for a ring or anything classy. I just want to exclusively date, with the goal of doing this the right way someday. No pressure, other than that, just day by day.
Oh my God. He's not responded once.
Nope.
To any of this. So then she put in here pictures of an article about Ron Owens. Is it that he's retiring? Gets a something test. I don't know. I don't know what that says. Something about her dad.
Not sure which attorney to send this to, as I am proceeding with the criminal case first, and you did not give me information for who to contact. Regardless, I sent this to your civil attorney. I realize that further evidence of my family's relationship with Joe Cotchett is not needed for this case, but I do feel violated.
Oh, it was an article about her dad and Joe Cotchett.
But I do feel violated with your contacting a family friend unnecessarily when, again, I have no formal representation at this point. Regardless, here's an article from the San Francisco Chronicle regarding a party thrown by Joe for my dad. This is not related to the civil case, and therefore I am not contacting your civil attorneys. It's the end of the business day, and I haven't heard from you. Regarding the criminal charges and DV charge, if your intentions were good, of course, I will not file them and I will drop the lawsuit. I am hoping your message on Sunday was an indication of you wanting what you claimed you did. If your intentions were to manipulate and intimidate me into getting an abortion, I will file it tonight. If you would truly rather a $120,000 civil lawsuit, criminal charges, and domestic violence charges, then date me. Unfortunately, I couldn't have more proof of coercion. Please let me know ASAP.
Oh my God. How is this not evidence of blackmail?
Right?
Right here. She's saying, I'm going to cost you $120,000 in all this litigation. And she did. And she did. If you don't date me.
And
this needs to get turned over immediately to the prosecuting attorney.
Not only that, but this case went to court and then they said, oh, no, you guys pay your own attorney's fees. Nothing's going to happen.
Yeah, they called it a wash.
Yeah.
Which is insane.
Confirming you saw this. I am going to file the police report at 5:30 if no response and file criminal charges before the civil case.
And we have reached the end of those text messages, and I think that we have
Your voice
proven...
will thank you.
What?
Your voice will thank you.
Yeah, thank God. I've had enough of those. Okay, let's get to the remainder of the super chats, and then we will. I'm gonna get out of here. All right. Last chance to send breadstick money. Thomas Williams, thanks for the 10. Says, enjoy your date tonight. I appreciate that. I will. Julie O, thanks for the 5. Says, wait, I could have gotten 45K every time a guy broke up? Son of a... Yeah, apparently. David Woodman C, thanks for the 5. Says, 45K might be worth it just to end it. Hey, these guys ended up spending a lot more than 45K, by the way, in the litigation fees and the lawyer's fees and all the other garbage that she, not to mention the emotional damage. Imagine what's your mental health worth to you?
Yeah, right.
Yeah, really. Like, what is your mental health worth? I'm so annoyed by all of this. Let's see if I got anything from Gingras yet, just in case. Did he email me back? Oh, sad. Sad face. No email back from David Gingras to my press inquiry yet. I will let you know, though, when he does, if he does, and what it says. All right. I have to decide which music video to leave you with tonight. And I'm feeling kind of worked up. So I think I'm going to leave you with Pond Scum Posse, baby, because that's one of my favorite songs, and I think it just encompasses how I am feeling after reading all of those text messages and the lies from her attorney about what is actually going on here. And I'm sure Greg Gillespie feels this as well. So good day, everybody. Have a wonderful rest of your day. Thanks for all the support and the views. Enjoy this song. See you, Brad.
One skull busted baby. Round up the one skull busted baby. Hey, hey, hey. You defame me or blame me for some crazy lady's fame game. I was minding my own business when that uppy sold a tail to the papers in the world claiming she got rails. Sending pics and flicks and texts and shit. Thinking no one will question it. Walk the dog, you don't know me. All my friends are fucking homies. She couldn't sell me baloney, and now a lawyer thinks I'm fucking on me. Car bomb, bitch, she ain't on me. Fake up in marathon. Saddle up, we ride it dog. Saddle up, we ride it dog. Pond Scum Posse, baby. Round up the Pond Scum Posse, baby. Hey, hey, hey. Your insults are war cries. Explaining leads to more lies. And slander on your shitty blog posts. Oh my god, you're so cringe, bro. Why you act like this is Jerry Springer? Oh, so hard by some podcaster. He seems half crazy, maybe drop as a baby. Or let pain eat, blasting bullshit on a pond. On his blog, no weirdness spawns. Saddle up, we ride it dog. Car bomb, bitch, she ain't on me. Fake up and have it dog. Saddle up, we ride it dog. Saddle up, we ride it dog. Pond Scum Posse, baby. Round up the Pond Scum Posse, baby. Hey, hey, hey. You explode some war crimes. Playing leads some more lies. Slander on your shitty blog post. Oh my god, you're so cringe, bro. Why you act like this is Jerry Springer? I'm so hard, but some podcaster. He seems half crazy, maybe dropped as a baby. Or let pain eating, blasting bullshit. What a pawn on his blog, more weirdness spawns. Saddle up, we ride a dog. Pond Scum Posse, gearing up the storm and backfield. Chopping keyboards, but still ain't no way, no how, no expert can conceal. That motherfucker was never fucking real.
That motherfucker back there is not real.
Car bomb, bitch, she ain't on me. Fake up and have it dog. Saddle up, we ride it dog. Saddle up, we ride it dog. Pond Scum Posse, baby. Round up the Pond Scum Posse, baby. Hey, hey, hey.
I was so lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices.
choices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna stay. No, I don't wanna say goodbye. This time I know my road is near its end. I almost felt my head is full of million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. And my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna stay. No, I don't wanna say goodbye. No, I don't wanna say goodbye.
So I take it that
Johnny's
you've seen
problem is he
Cameron
should have come
John's bedroom
storming
before.
in there with
Yeah.
a string of
Do you
garlic
recall what
and
he
some
went
holy
into
water.
Mr. Jepson's
cross,
first
a crucifix
bedroom?
one.
May the
Do you
power of
recall,
Christ
or no,
compel you.
No, I don't.
You
Sure,
realized
Miss
his house
Hubbard,
was infested with
just after
succubuses.
that,
And
there's a photo here with you of what it, yes. Do you recall whether it was there when you arrived in the afternoon? I don't remember seeing it now. So while she
No wonder he said drown her before you burn her.
Oh my god.
You-
Your next witness?
Now I know
Witness
why you wanted to drown her.
Lasis. And that is
Witness
also
lives in
by
Romania.
video.
Is that correct?
That